Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Several people had asked me to do a video on the Emergencies Act, and I said, we don't really need a video on this. It's only the most extreme voices on Twitter that are really pushing for this, and there's no way that the government would take that big of a step here. It's just not called for. I don't see it happening. Well, now here I am doing a video on the Emergencies Act because Justin Trudeau has indicated that he plans to do exactly that. He plans to invoke it. So this is a hell of a thing. This is a really big deal. And to explain why it's such a big deal, we should look a little bit at the historical context. The Emergencies Act is the successor act to the War Measures Act. And the War Measures Act has been invoked 3 times in history. The first time is during World War I. The second time is during World War II, so world wars. And the third time is during the October crisis. And during the October crisis, if you're not familiar, the FLQ set off more than 200 bombs. They had stolen a tremendous amount of dynamite, several tons of dynamite. They were kidnapping people. This was a really big deal. And in fact, invoking the War Measures Act during the October crisis was itself sufficiently controversial that it resulted in the end of the War Measures Act. It actually resulted in getting rid of the War Measures Act and replacing it with something that is a little less sort of all-encompassing, that provides less sweeping powers. So that's a really big deal. Now, in terms of the Emergencies Act, the number, we can go through every instance when it's been invoked. Here we go. All right, so it's never been invoked. It has not once been used. This would be the first time in ever that the Emergencies Act is being used. And so, that's always a really big deal, especially because once something tends to be used once, they'll come back to it again. So we're opening a really serious door here. And when we think about it, is there a world war going on? I don't see one. Is there something on the lines of the October crisis? I just don't see it. You can say, hey, this protest is, you might really hate this protest. It might be really noisy and you might really hate the people involved, but it's still not the October crisis by any stretch of the imagination. And I know that there is a recent arrest in Coutts, and I'm going to talk about that as we go through. So let's have a look at the Emergencies Act here and what it says, what it does, what the preconditions are. And I'm going to really be focusing on the ones that apply to this particular situation, because there are some other provisions that apply to things like a war or a, some sort of public crisis, if we were hit by a meteor or something like that. But let's look at the ones that would potentially, or at least that they're going to claim apply here. So, Emergencies Act. All right. Now, there's a few things we really need to look at here, and one of the important ones is in the preamble. And this is a direct result of the War Measures Act and it being seen as sort of a potential problem. So this clause right here says, and whereas the Governor and Council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged even in a national emergency. So what this basically intends to do is to put the Emergencies Act under or subordinate to the Charter. The Charter is still supposed to apply, although, this does explicitly attempt to abridge certain charter rights, and ultimately that would be subject to scrutiny in terms of Section 1 analysis, whether or not it's a right that can be sufficiently, can be curtailed in the context of a free and democratic society. I'm paraphrasing here rather than using the direct language, but so let's carry on here. And the next section we're going to look at that's really important here is this section here on national emergency. So for the purposes of this act, we'll get that on the screen properly. A national emergency is an urgent and critical situation of a temporary nature that A, seriously endangers the lives, health, or safety of Canadians and is of such proportions or nature as to exceed the capacity or authority of a province to deal with it, or B, seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada, and that cannot be effectively dealt with under any other law of Canada. So these are sort of preconditions here. Now, in terms of does it seriously endanger the lives, health, or safety of Canadians? Well, we've seen 0 bombs go off. We've seen 0 fatalities. We don't really have I don't think there's any serious injuries at this point. And in terms of exceeding the capacity or authority of a province to deal with it, I don't think we're there yet either. Now, the police have been very hands-off, and I've explained some of the reasons why. But in terms of this, the police can't just say, hey, listen, we've done nothing, so we need the most extreme and extraordinary powers imaginable. That is very concerning. And in terms of this, as to whether it seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada, that would be something like if we have an armed uprising that's actually threatening to overthrow the government. We haven't got that. We've got bouncy castles and, really annoying honking. We've got stuff that people are pursuing, lawsuits about and injunctions and so forth. This is not that the government is falling. In fact, the government is still doing its thing. It's still up and running. Nobody's taken a shot at anything like that. So I don't see this. And that cannot be effectively dealt with under any other law of Canada. I mean, we have tons of laws that would now allow them to take various steps here. Canada is not a country that is short on laws. So it's really unclear as to see, I don't see how we actually meet this national emergency criteria here. I think it's a real stretch, and it's a real stretch in ways that should be real concerning to a lot of people. All right, so let's have a look here. I'm skipping over the public welfare emergency because that deals with fire, floods, droughts, storms, earthquakes, and other natural phenomenons, etc., etc. So that's not the criteria here. And so what we're looking at here is public order emergency. This is what they're going to be saying is applying. Again, this is what they're claiming applies in this circumstance. So a public order emergency means an emergency that arises from threats to the security of Canada and that is so serious as to be a national emergency. So when I read you that bit about the national emergency, and then we moved on to another definition, the reason why is that the public order emergency, in order for it to be a public order emergency, it first has to be a national emergency. And again, I don't think we're at a national emergency. I don't see it. I think that this is being overblown for the purposes of invoking this incredibly broad and, act that gives them very sweeping powers. So that's a concern to me. So declaration of a public order emergency. They say when the governor and council believes on reasonable grounds that a public order emergency exists and necessitates, so requires the taking of special temporary measures for dealing with the emergency, the governor and council, after such consultation as is required by Section 25, may by proclamation so declare. All right, so let's skip ahead to Section 25 because that talks about unnecessary precondition here. So Section 25 here is consultation. Subject to subsections 2 and 3, before the governor and council issues, continues, or amends a declaration of a public order emergency, the lieutenant governor and council of each province in which the effects of the emergency occur shall, which means must, be consulted with respect to the proposed action. So they have to be brought in and this has to be discussed with them. And then there are 2 more subclauses here that also affect things. So number 2 is where the effects of a public order emergency extend to more than one province, and the governor of council is of the opinion that the lieutenant governor and council of a province in which the effects of the emergency occur cannot, before the issue or amendment of a declaration of a public order emergency, be adequately consulted without unduly jeopardizing the effectiveness of the proposed action. The lieutenant governor and council of that province may be consulted with respect to the action after the declaration is issued or amended, and before the motion for confirmation of the declaration or amendment is laid before either House of Parliament. So essentially this is an emergency provisions clause. Let's imagine the meteor strike, and that again applies to a different subsection, but something where it's happening so immediately that you have to get moving right away. In that case, they're saying, okay, you can skip over the consultation initially, but then you have to go back and consult. So if there was suddenly, if suddenly Quebec was in a military uprising, then, they might be able to say, okay, before we talk to you, we're going to make this declaration. It would be a very unusual circumstance where this comes up. And the next is indication. The governor and council may not issue a declaration of a public order emergency where the effects of the emergency are confined to one province unless the lieutenant governor and council of the province has indicated to the governor and council that the emergency exceeds the capacity or authority of the province to deal with it. So I don't know that that is the case here, but again, the national emergency aspect is the big sort of issue here. Now, what does all of this allow them to do? I did mention that that this is supposed to be subject to the Charter of Rights and Freedoms, but this provides a lot of powers. So the declaration has to include certain language, and the first sort of elements here, it has to specify concisely the state of affairs constituting the emergency. So it has to say what the emergency is about. You can't just say, we have a general emergency and we're just going to keep these powers on the shelf for whenever we want them. It's got to be specifying what exactly you're talking about. B, the special temporary measures that the governor and council anticipates may be necessary for dealing with the emergency, and we'll talk a little bit about that as we go. And C, if the effects of the emergency do not extend to the whole of Canada, the area of Canada to which the effects of the emergency extend. And this allows them to make certain orders and regulations. And let's have a look at what those are. So while a declaration of a public order emergency is in effect, the governor and council may make such orders or regulations with respect to the following matters as the governor and council believes, on reasonable grounds, are necessary for dealing with the emergency. So A, the regulation or prohibition of any public assembly that may reasonably be expected to lead to a breach of the peace. Now, I should note here that that's actually already something that they can prohibit, and they have not declared that that is the case with respect to these public assemblies because they haven't gone in and invoked those powers yet through the ordinary course of the criminal code. So that's kind of interesting. Travel to, from, or within any specified area. The use of specified property. So, that's pretty broad. The designation and securing of protected places. The assumption of the control and the restoration and maintenance of public utilities and services, the authorization of or direction to any person or any person of a class of persons to render essential services of a type that that person or a person of that class is competent to provide, and the provision of reasonable compensation in respect of services so rendered. This is a hell of a provision when you think about it, because this is essentially a dragooning provision where they can, essentially conscript you into providing services in various ways. They may say, hey, listen, you're a lawyer, you have to go and do certain legal related tasks, or you are, again, this is for essential services, but it does provide for you to have to work in those essential services regardless of whether or not you want to. Now, there is a provision for compensation for that, so it's not sort of unpaid labor, but it is unfree labor that this is talking about. And the imposition on summary conviction of a fine not exceeding $500 or imprisonment not exceeding 6 months, or both, that fine and for that fine and imprisonment. Now you might be saying, why $500? $500 doesn't seem like a whole lot of money. Well, it's because nobody actually expected to use the Emergencies Act. It's been sitting there with nobody looking at it, and so nobody has updated these fine amounts. So these haven't been adjusted for inflation. This was supposed to be a really big fine, and it's kind of gotten eaten away by inflation. Or B, on an indictment of a fine not exceeding $5,000, again, same issues for that number, or imprisonment not exceeding 5 years, or both that fine and imprisonment. I'm pretty sure that if they were to update the Emergencies Act, they'd update those fine amounts to be much higher for a contravention of any order or regulation made under this section. So if you breach those orders, 6 months in jail and $500 on summary conviction, or 5 years in jail. Again, that's a maximum, not a minimum, and $5,000 if they proceed by indictment. So that is a bit of a big deal there. And there are provisions for, it can be revoked, it can be continued. I'm not going to get into all of that. I'm just sort of trying to keep this real brief, in part because this wasn't a video I expected to make. This wasn't the video I wanted to be recording today at all. All right, so there's some other restrictions here that I want to talk about, and these are kind of important, and there's some historical reason for these restrictions. So first, nothing in this act shall be construed or applied so as to confer on the governor and council the power to make orders or regulations, first altering the provisions of this act, which essentially means that they can't say, hey, we're going to use our emergency powers to give ourselves more emergency powers. That's a really important limitation, because otherwise things spiral out of control really fast if you give the government the power to just award themselves freely extra power. I mean, I get the irony here. Now, the next one here is nothing allows them to provide for the detention, imprisonment, or internment of Canadian citizens or permanent residents within the meaning of subsection 2 sub 1 of the Immigration and Refugee Protection Act on the basis of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. And you might be wondering, listen, they already said that this is going to be subject to the Charter, and the Charter says you can't discriminate on those grounds. Why would they explicitly put in that provision? What is that about? Well, that's getting back to the historical context and talking about the War Measures Act. I mentioned previously that the War Measures Act had been invoked during the First World War and the Second World War. And both times, one of the things that they included in that invocation was the rounding up into camps of racial and or ethnic groups. In the First World War, this was used to affect the Ukrainian-Canadian internment. So they were rounding up Ukrainians and, some other groups as well. In the Second World War, this was used to justify the internment of Japanese Canadians. So the history of racism with these kinds of powers was very much on their mind when they were creating this act. But I mean, when we think about that in terms of the historical context for these kinds of powers, it hasn't always been used in ways that that are laudable. And in fact, even the October crisis, and I mentioned they've got, they had kidnappings, they had bombings. It's really controversial, and in fact, the invocation of it may be one of the reasons why the Parti Québécois became a power in Canada, was as a reaction to and a rejection of this sort of thing. So this is huge, and the potential for backfire of this kind of thing is tremendous. I am really worried about this step being taken. As I mentioned before, when they say a national emergency is, one that exceeds the capacity or authority of a province to deal with it, I know there's going to be people probably in the comments and elsewhere saying, listen, did you not hear about that arrest in Coutts? And if you haven't heard about it, they arrested 11 people, and they found them with body armor, a collection of firearms, a machete. I don't know why they mentioned the machete, but okay. And they say that they were intending to use violence. But this doesn't show that we have exceeded the capacity of, our police forces to deal with things. In fact, what this shows is that our police forces are effective, that they're monitoring the situation, that they, were able to detect this and wrap it up before it became an issue. Now, these are people who they've been arrested and presumably charged, but they enjoy the presumption of innocence, and I can't say what'll happen at their trial. I don't know how that's going to go down the road. I don't represent any of these people, but this is a thing, right? This is the RCMP seems to be handling this, and so it's very difficult to see why we need these powers in terms of the Ontario, the Ottawa protests. Again, right now they're not particularly violent. There have been some reports of scuffles and clashes. There was a report of an arson that frankly has been debunked. That one I don't think really carries a whole lot of weight because it just makes no sense. And the original claimant has backed away from a bunch of the things that they claimed on that one. I don't think we're at, this is not World War II, friends. We're not there. And, as I said, this power has never been invoked, and it ought to have stayed that way. The notion that this is going to be invoked about protests is one that really concerns me. Even if you absolutely hate this protest, even if you absolutely want to see this protest shut down, there's all sorts of other ways to do that other than the Emergencies Act. This is wild. Yeah, I mean, we're making history today, and for all the wrong reasons. I'm very concerned about what this is going to do. I'm very concerned about what, the potential for this to go very wrong is very high. So, yeah, I guess that's the video here. Thank you for watching. I kind of hope this one scares you as much as as it does me, because this one is a real concern for me. I'm really worried about what's going on here, and we'll have to see sort of what's going on. Anyway, thank you for watching. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Firearms Association; Kyle Martin, the CCFR and the Canadian Shooting Sports Association; at the $30 level, Sights and Arms Limited and Marc Levier Demour; and at the $20 level, Peter Hilger, Mark Whittington, Jane Baben Luxer, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delso. Thank you as well to all of the $10 supporters who are going to be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge, and yeah, I really don't know what else to say. This is a big deal. Yeah. All right. See you next time.